When it comes to motoring offences, many arguments are raised to try to avoid liability by a defendant. One such case is the case of Creed and Scott from 1976. Here's what happened. A police officer was following a vehicle at an even distance for some distance and estimated the speed at between 48 and 52 miles per hour, in contravention of the speed limit, which at the time and on that road was 30 miles per hour. The police officer stopped the driver, advised him that he was driving at speed and cautioned him. The driver didn't make any response to the caution. The police officer asked for a name and address, which the driver gave to him. However, when the case went to court, although the defendant wasn't present, he was represented by counsel who made a submission of no case to answer on the basis that there was no evidence of the driver's identity, only what the police officer was saying. The submission of no case to answer was overruled. There was no further evidence submitted on behalf of the defendant, and the defendant was convicted. However, the defendant appealed this conviction to the Queen's Bench Division of the Divisional Court. The lower court thus stated the case and the question for the court to answer as to whether or not it was right to convict this defendant based on the evidence before it. That evidence, of course, being that the police officer was following the vehicle, observed it driving at speed, estimated the speed at between 48 and 52, which was well over and above the 30-mile-an-hour limit, stopped the vehicle, cautioned him, and was provided a name and address. In answer to cross-examination questions, the constable gave evidence that although he didn't know the driver, he was given the name and address. He said that he had to accept these details as being his when he issued the driver with the form to produce his documents at the police station at a later date. There was no other evidence before the court. Ultimately, the court's decision was that it didn't matter whether or not a driving license was produced in evidence to prove who this defendant was. The fact that these details were given to the police officer at the time, and then, although not physically present, was represented by counsel by the same name and address, this defendant was the correct defendant in question, and thus, in the absence of any other evidence, and given the totality consideration of all of the evidence before the court, the conviction was upheld. The Divisional Court said that in its judgment, the justices did have some evidence of the identity of the driver, and at the end of the day, it was the only evidence that they were faced with, and they were fully justified in convicting him. So this just goes to show that if you are given a fixed penalty and you choose to fight the case instead on a limited basis and it fails, you may face subsequent costs and an increased fine for the offence itself. So I hope you found that interesting. Please remember to like and subscribe, and thank you for watching.